My name's David Christie. I'm here at the Law Society in the boardroom. Maybe we should close that door. You might hear that audio. And this is the first time that I've been involved with presenting CPD by Zoom. So if you can bear with us if there's any technical difficulties. We have another couple computers here at the Law Society watching to make sure that things are going smoothly. Yeah, and I see 40 people now signed in. That list is growing. Yeah, it's going up even now as I'm looking. So, okay, it's 12 o'clock, so I'll start. This is CLE for the Mental Health Act. And well, I'll start by saying the Continuing Professional Development Committee of the Law Society of Yukon is pleased to present this CPD, Mental Health Act Overview and Practical Tips. And this course has been approved for 1.5 hours of credit towards the 12 hours required annually for each member. And I'll introduce the panel presenters today who are beside me. First, to my right is Jim Tucker of Tucker Carruthers. And Jim is a lawyer, and he's also the chair of the Capability and Consent Board. He'll provide you with an overview of the Mental Health Act, and his role as chair, and as well as processes and practical tips. Mike Reynolds is to my left of Ostring, Fairman, and Fekete, and Mike is a lawyer and doctor's counsel. He'll provide information on the forms, technical issues, and tips connected to mental health review board hearings. And myself, I'm a lawyer who at times over the years I've acted for patients who are the subject of Mental Health Act applications. And I'll review capacity and client management issues, as well as hopefully providing some useful practical tips for lawyers. Now, we've allotted about 10 to 15 minutes for each of us. And then we've saved time at the end for a question and answer session via chat messages, and we'll be monitoring that as well. So hopefully there's some good questions to follow. There's also some helpful documents that have been provided by email to everyone who registered, and you could follow up if you didn't receive those, and as well as some links to more documents. And we'll be sharing a one-pager flowchart during the presentation as well. So all that being said, we'll start with Jim Tucker, who will provide his portion of the presentation.
Hello, everyone. The Capability and Consent Board is an administrative board created under the Care Consent Act. It is charged with reviewing matters under both the Care Consent Act and the Mental Health Act. Under the Care Consent Act, the board is comprised of members of Yukon Medical Association, care providers, and members of the Law Society, and others, presumably laypersons. Under the Mental Health Act, Section 28 dictates the composition of the board for a hearing as being the chair or a vice chair. That's usually a lawyer. At least one member of the Yukon Medical Association, and at least one member who is not a healthcare provider. The role of the Capability and Consent Board under the Mental Health Act is to automatically review every case where there is an involuntary admission of a patient, a renewal of an involuntary admission, an application to transfer a patient who has been involuntarily admitted to a hospital outside of the Yukon. And we also review every certificate filed with the board related to an involuntary admission. Essentially, the Capability and Consent Board oversees the management of patients held involuntarily. Normally, that oversight does not extend to reviewing treatments provided to patients, except for certain types of treatments specified in the Act or the regulations. While reviews are conducted automatically, hearings don't always occur. Hearings are required under the legislation for the review of involuntary admissions and renewals and transfer applications, unless the patient is capable of waiving his or her rights to a hearing and actually does so. Anyone with a substantial interest in the matter can also request a hearing for the review of any certificate issued under the Mental Health Act or a decision to transfer an involuntary patient to a hospital outside of the Yukon. Reviews and hearings can and do occur under the Care Consent Act also, but they are relatively rare occurrences. By far, most of the matters dealt with by the Capability and Consent Board are reviews of involuntary admissions and applications to transfer patients to hospitals outside of Yukon. We have emailed out, I think, as part of the materials for this talk, a spreadsheet with the heading Summary of Process, Mental Health Act, and Care Consent Act. From the numbers on that document, you will see that the numbers of matters being dealt with under the Mental Health Act are on the rise. Mental disorder is defined in the Mental Health Act as a substantial disorder of thought, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life. While that definition may be a mouthful, it is a definition which allows the Mental Health Act to be triggered in appropriate circumstances without a person's condition having actually been diagnosed. In our society, mental illness is prevalent and mental disorders are common. I believe there are many people suffering from mental illnesses of varying degrees in our society who are never and should not ever be dealt with through the process of involuntary admission under the Mental Health Act, because that process necessarily involves depriving sick people of their liberty. That said, there are situations where it is appropriate and necessary to do so. And those situations are assessed through a graduated process employing the basic test in the Mental Health Act. The process under the Mental Health Act can be initially triggered by, first, a physician who has examined a person, that's under Section 5 of the Act. Second, an application can be brought before a judge by a person who reasonably believes that another person suffers from a mental disorder. That's under Section 6. Anyone can bring that application. Third, a judge can issue an order of his or her own accord for an involuntary examination of a person if that person's been charged with certain offenses. That's under Section 7 of the Mental Health Act. And fourth, a peace officer can trigger the process as well, and that's under Section 8. The factors which would permit any of those persons to trigger the process of involuntary admission are that they either have to have, first they have to have a belief on reasonable grounds that the person that they're concerned about, as a result of a mental disorder, is likely to cause serious bodily harm to themselves or to another person, and is either threatening or attempting to cause bodily harm to themselves or has recently done so, is behaving violently towards another person or has recently done so, or is causing another person to fear bodily harm or has recently done so. Or, so that's the first set of circumstances that can be used to trigger the Mental Health Act. The second set of circumstances would be if the person seeking to trigger the act believes on reasonable grounds that a person, as a result of a mental disorder, shows or has recently shown a lack of ability to care for themselves and is likely to suffer impending serious physical impairment. If either of those factors are present, any of those people, that's pretty much everyone when you think about it, can trigger an involuntary assessment, which is the first stage of the process. This results in the individual being detained for 24 hours under Section 10 of the Act. If that occurs, the person is immediately, upon being brought into the hospital, or is immediately examined by a physician or a nurse who consults with a physician. If the physician or the nurse concludes that the person does not suffer from a mental disorder, then that person is released. So that's the first check. If the physician or nurse concludes that the person does suffer from a mental disorder, then the person can be detained for up to 24 hours. If that occurs, then the person has to be further assessed within that 24-hour period following their arrival at the hospital by two other physicians, usually at least one of whom is a psychiatrist, to determine their need for care and treatment. If those two doctors each complete and file a certificate of involuntary admission with the Care Consent Board, both confirming the involuntary admission, then the patient is involuntarily admitted, subject to a review by the Capability and Consent Board. So when we get those two certificates, the board then must review the involuntary admission within 7 days of their receipt. In conducting its review, the Capability and Consent Board reviews all the forms and medical records, and if a hearing is conducted, it receives the evidence of the doctor and the patient and anything else it considers relevant. The Capability and Consent Board reviews the material in light of the same test employed by everyone else in the process. As chair of the Capability and Consent Board, when there is a hearing, I am charged with attempting to resolve the matter informally if that's at all possible. That is in part because conduct of hearings runs a real risk of damaging the relationship between the patient and the treating physicians. I also, as chair, have a significant degree of flexibility in how I conduct the hearing, which is obviously necessary given the nature of the subject matter and the parties involved. Mental illness can be insidious. A person suffering from a mental disorder may be the very last person to recognize that he or she has a problem. My tip, it's not a tip really, but it's advice. If a person comes to you with a concern regarding a family member, a friend, or an acquaintance, where they describe a situation where that person might have a mental disorder as defined in the Mental Health Act, and that person might present a danger to themselves or to others, or might not be able to take care of themselves, it might be useful to note the mechanisms available in the Mental Health Act. Do remember, though, that the test is not only whether a person suffers from a mental disorder, but also whether there is a risk or danger to the person or someone else. Thank you.
Dave, you want to just help me get that flow chart up?
Yeah. Okay, we're going to try sharing a flow chart here while Mike gives his presentation.
All right, hopefully everyone has the involuntary admission under the Mental Health Act flow chart up. It's probably a little bit easier to look at that than look at my face through the next 10 minutes here. They did a terrible job with makeup over at the Law Society building today. I don't know what to say. In any event, I'm going to focus obviously on involuntary admission under the Mental Health Act. Surprise. I'm going to build on a lot of what Mr. Tucker has said. And I do want the flow chart up just so it may help to make sense of some of the things I'm going to say. So I'll begin here by saying that involuntarily admitting someone under the Mental Health Act is and really should be a very big deal. Many of the individuals who are involuntarily admitted are extremely sick and in obvious need of immediate and substantial treatment. That doesn't decide the issue, however. Have to remember the Charter of Rights and Freedoms, as we lawyers have to remember in pretty much everything we do. The Charter obviously applies to everyone, but I'd suggest it especially applies to our most vulnerable population, and that would be the mentally ill or mentally disordered under the Act. The Charter, as we know, does allow for the suspension of our rights in very limited circumstances. By involuntarily admitting someone at the hospital, we're absolutely suspending several of their rights. For these individuals, or many of them, we're holding them against their will or against their wishes. We're detaining them in the hospital. A lot of them, as Mr. Tucker pointed out, do not believe they have a mental disorder, and they certainly don't want to stay at the hospital. We're allowed to detain these individuals under the Mental Health Act because we have a very clearly outlined process with strict and expedient timelines that requires the careful consideration of several physicians. Some of the admissions, there's as many as 3 or 4 different physicians involved, one of whom is usually a psychiatrist. Depending on their shift schedule, we may have up to 2 or 3 different psychiatrists involved in one particular admission. The process also provides for the patient to have legal counsel. We'll hear from Mr. Christie in a few minutes. And the entire process of involuntary admission is subject to the review and oversight of the Capability and Consent Board. We just heard from its chair, Mr. Tucker. Do have to say that the physicians are extremely cautious about involuntarily admitting anyone under the Mental Health Act. It's usually a mechanism of last resort. Also, many individuals that come to the hospital with what appears to be a mental disorder do not get involuntarily admitted. The process of involuntary admission is not completed for a variety of reasons. A lot of times the patient sobers up or starts to engage with the physicians in a meaningful way, and it becomes clear to everyone that they no longer meet the criteria for involuntary admission. As Mr. Tucker alluded to, there's a lot of off-ramps in the involuntary admission process. The process itself is driven by forms. Taken together, the forms do provide the history of the admission and certainly much of the relevant evidence to prove it. On the other hand, the forms are also the formal mechanism through which an involuntary admission is often concluded. Each form provides several options for the physicians to end the involuntary admission. Now, we'll refer perhaps to the flow chart. Hopefully you had a chance to have a little bit of a look at it. There's different pathways to involuntary admission. Mr. Tucker's covered a lot of that off. I'll be brief. There's 3 primary intake points for the early stages of an involuntary admission. The physicians, most often at a hospital, in the emergency department in particular. The RCMP, usually they're responding to calls from concerned citizens, family members, friends of the individual at issue. Nurses, most commonly at community nursing stations. Not every community has doctors, but a lot of them have nurses and some nurse practitioners. So there's a way that they can initiate at least the assessment under the Mental Health Act. Another intake point is an order to apprehend, which is issued by a judge, and it enables the RCMP to apprehend an individual and take her to the hospital for assessment. The risk of repeating Mr. Tucker, I'm going to go over the legal test, at least for the initial stage of involuntary admission, and it is important. At least by the time I'm done, I think everyone will have a very good sense of the process. So the involuntary admission process itself is started by one of several forms and gone through a few of the authors of those forms, but all of the forms basically have the same legal requirements. So the person completing the form must believe on reasonable grounds that the person they're filling the form on, the subject of the form, as a result of a mental disorder, Mr. Tucker gave us that definition, that person is threatening or attempting to cause bodily harm to herself or has recently done so, and is likely to cause bodily harm to herself, or is behaving violently towards another person, or has recently done so and is likely to cause bodily harm to another person, or is causing another person to fear bodily harm, or has recently done so and is likely to cause bodily harm to another person. Or finally, the person has recently shown a lack of the ability to care for himself and is likely to suffer further serious impending physical impairment. So a lot of words in there that have to be deconstructed, but the test at this stage is not certainly not onerous, but there does have to be some evidence to support it being passed. And what I will say is the requirement here, at least in the initial stages, is that something has occurred or is occurring at the time of the assessment, and there must also be a tangible risk that this thing will actually occur in the future. It's a conjunctive test. Both things have to be met. So we look at the various forms. The most common form that initiates the process is called a Form 4. It's the recommendation for an involuntary psychiatric assessment, most often completed by a doctor at an emergency department, commonly Whitehorse, Dawson, Watson Lake. I think those are the only emergency departments in the Yukon. The police can also fill out a form if they get around to it. It's called a Form 3. And the police officer must believe on reasonable grounds that the person they're apprehending under the Mental Health Act may, at that particular time, be suffering from a mental disorder. And then they must meet the legal tests that Mr. Tucker and I have outlined here, at least one of them. The RCMP member will then transport the person to the hospital, and it's Whitehorse General Hospital most often. And this results in the physicians examining the patient and completing a Form 4. As we mentioned, a nurse can also complete a form that starts the involuntary admission process. That's called a Form 5. It's most often occurring, as I say, at a community health center, and there does have to be a consultation with a physician, usually an emergency doctor here in Whitehorse. It's the same legal tests that we've mentioned several times that have to be satisfied. And of course, once the Form 5 is completed, the patient at that point in time is sent to Whitehorse, often by a medevac flight. The judge part of this, that's order to apprehend, that's Form 2. The judge must believe on reasonable grounds that a person will not consent to an examination by a physician, and at least one of the 4 criteria we've been talking about have been met. Usually the Form 2 or the order to apprehend is initiated by social workers, perhaps family members, on occasion some doctors who are quite concerned about their patients. It is essentially a paper application to a judge, and then if it's successful, the RCMP would of course do the apprehending and take the individual, most often Whitehorse General Hospital. The main form in the involuntary admission process, post Form 4, as we see on the flow chart here, this is kind of what gets the job done in terms of getting someone involuntarily admitted. It's called a Form 7, a certificate of involuntary admission. There's, in order to involuntarily admit someone, there has to be 2 of these forms completed. And that requires 2 separate assessments by 2 different physicians at Whitehorse General Hospital. That's the only place where a Form 7 can be done. It's also the only place where a patient can receive psychiatric care. And these 2 forms and the related assessments have to be completed within 24 hours of the date and time on the Form 4. So it's pretty quick. And as you might imagine, it's sometimes problematic, as it could be difficult to come up with an actual working diagnosis on an individual within 24 hours. And we have to expect the doctors aren't doing their assessment on the 23rd hour. They're doing it whenever they have a moment to, and the hospital is a pretty darn busy place lately. This often results in something called a differential diagnosis, where the doctor will, or psychiatrist will suggest, look, this could be psychosis, this could be schizophrenia, I'm not really sure. That still works as a diagnosis. And over time, usually it's clarified. There are some diagnostic tools that can come into play, but perhaps not within 24 hours or 12 hours or whatever the actual timeline is the physician's working with. Now, there's 3 main requirements for a Form 7. It has to be a diagnosis, which we just covered. The physician or physicians have to confirm that it's their opinion that the severity of the mental disorder suffered by the patient is such that unless the patient remains in the custody of the hospital, it's likely to result in serious bodily harm to himself or herself or another person. So it could be, you can think of that as homicidal ideation or suicidal ideation, with a potential for that to actually come to light, or come to pass. And then, or the patient's impending serious mental or physical impairment. Most often we find this applies to schizophrenics who go off their medication. We know they're going to continue to decline in their condition, or decompensate. It's sort of a one-way street. Third criteria, which often seems to be something I have to work on with the doctors, is that the patient cannot be suitable for admission as a voluntary patient at the hospital. And why this can become difficult is sometimes if the patient has attempted suicide, they may be intubated, they may be unconscious. There's some inferences that have to be made in order to satisfy the evidence for that particular point. Now, in terms of timelines, the Capability and Consent Board has 7 days from the date of the second Form 7 to conduct a hearing or review in relation to a patient's involuntary admission. The patient can challenge the initial admission or the continuing admission, or both. So essentially the patient would be saying, look, I shouldn't have been admitted here in the first place, or I shouldn't be admitted now, maybe I should have been earlier, or both. The purpose of the hearing is for the board to determine if it will uphold the involuntary admission. And a hearing before the board will occur unless the patient's counsel is able to secure a waiver from the patient. In that circumstance, the board will simply review all the documented evidence and follow up with counsel if needed. If it does proceed to a hearing, the physicians who complete the forms and the patient are both represented by counsel, and each may testify at the hearing. Lately, because of COVID, what we've been doing is, at least for my clients, we've been filing written evidence. And this simply expedites the hearing process, because any hearing we've been doing is by teleconference, which leads to its own issues, as anyone who's been in the criminal courts in the last 4 months can attest to. Also, the benefit of the written evidence, and Mr. Tucker mentioned this at the end of his speech there, was it's very difficult for the physician to rebuild a relationship with the patient after they've both been in the same hearing room and the patient has been listening to the physician talk about his or her condition that he or she may not actually even believe in or agree with. With the written evidence, it just seems to be much easier for the physician to continue to work with the patient after the board confirms the admission. They don't have to listen to the physician talk about them for 45 minutes. Proof or standard of proof at a hearing is on a balance of probabilities, so more likely than not, and the burden obviously rests with the physicians to prove that. If the board upholds the involuntary admission, as we can see on the flow chart, hopefully it makes sense, then we're into extend the patient's involuntary admission for a period of 21 days, and that runs from the date of the second Form 7. So then we're in a 21-day cycle. And if we wish to extend the involuntary admission, and sometimes that does happen, not everyone's condition improves significantly enough over those 21 days to be decertified under the Act. They require more time. Then we would simply start the process anew through something called a Form 7 or Form 11, which is a renewal form. But it's basically the same process all over again. Last thing I wanted to talk about was transfers under the Mental Health Act. This usually occurs when a patient's in the hospital and the physicians recognize that they require a higher level of care than can be offered here in order to get better. Now, of course, before we can even get to that point, the board has to uphold the patient's involuntary admission. And then, should the physicians determine that a higher level of care is necessary, to fill out a transfer application. Now, hearings or reviews of the transfer applications can take place at the same time as the hearing or review of the involuntary admission. Often they do. The key issue for a transfer is whether the patient requires a higher level of care. We do have a secure medical unit at the hospital, but it's definitely not a psychiatric inpatient unit. It's far from it. Patients can only be transferred to hospitals with an accredited psychiatric inpatient unit that can provide full-time psychiatry, 24 hours around the clock, all necessary care and supports for medication trials, improve diagnostic services, which would come with the care team at a psychiatric inpatient unit, programs and therapies, and in most cases, the patient would be transferred to British Columbia or sometimes Alberta. Now, a patient can, of course, challenge the transfer or waive his right to challenge it. A hearing or review would then occur. And the physicians, again, must satisfy the board that the transfer is necessary on the balance of probabilities test. I'll just end by saying, especially in the last 4 or 5 months, securing a bed for a patient at an outside facility can be extremely challenging. And thank you. I'll pass matters off to Mr. Christie.
Okay, just need a second to set this up here. Okay, for my segment, I'll be speaking as a lawyer who represents clients who are the subject of a Mental Health Act application. And I've broken this down into 6 topics. First, the role of patient's counsel. Second, instructions. Third, capacity. Fourth, the best interests of the client. Fifth, substitute decision makers. And then lastly, I'll touch on relevant sections of the Code of Professional Conduct. So I've been practicing in this area for close to 18 years, and I find it rewarding and important work. However, it is also challenging. And I think it's fair to say that this type of work is not right for every lawyer. This is an area of interest to lawyers who are patient and empathetic. And I think the most suitable lawyers for this area of practice are passionate about advocating to protect the legal rights of vulnerable persons. Now, as we've heard, people are committed under the Mental Health Act, or proceeding is commenced, because essentially there are grounds to believe that they are at risk either to themselves or to others, and that they are suffering from a mental disorder. And quite often with clients, I emphasize that they haven't done anything wrong. There's sometimes an assumption on their part or a belief that they're in trouble. And there's, it's not uncommon for a lot of mental health patients to have had also been criminal clients and otherwise engaged with legal aid in that context. So yeah, I emphasize they haven't done anything wrong and that people who care about them want them to get better. Now, people could be wrong, as I'll talk about as well too. Sometimes the best intentions aren't always correct. So legal aid, I want to speak a little bit about that process. Legal aid automatically assigns a lawyer without charge, it's free, to help anyone and everyone who is the subject of an application under the Mental Health Act. And there's a careful confidential process for how that occurs, which I'll talk about in a moment. But I will also say there's no application process or financial eligibility test for this area for these clients. And conversely, we do have the financial eligibility test for criminal and family law matters. Legal aid, so legal aid has a roster of assigned duty counsel for a number of different areas of law, for all areas of coverage we have, but in particular for mental health, we have a roster of assigned duty counsel who provide this service 24/7, 365 days a year. And hearings, hearings are commenced by forms, or the matters are commenced by forms. And those are sent from the hospital to legal aid in a secure manner. We treat those as very confidential and very carefully, and they are provided to assigned duty counsel. And quite often with this type of work, the client meetings and hearings occur during evenings and weekends. It can be like rounding cats sometimes to organize the tribunal and doctor and work it out with the staff and the lawyer. But it's typically those are done evenings and weekends. And they can occur on holidays, as I said, all year round. And if a legal aid lawyer, despite their best efforts, is unable to connect with and receive instructions from a patient, legal aid does do its best to try and accommodate that by providing a different lawyer. But I mean, sometimes it's a resource issue. Sometimes there's conflicts of interest, and it can be a challenge, and it just can be exacerbated by the initial lawyer not being the right fit. But we do try to accommodate the best. Legal aid tries to accommodate the best they can. And also, as I've always emphasized with the legal aid lawyers, is that it's always to try to do their best to be understanding with these patients, because they're not, by the very nature of this work, they're not always themselves as they normally would be, and whether it's psychosis or delusions. And so they don't always present as they often don't present as the ideal or optimal clients. There can be conflict sometimes just for the lawyer to try and make a connection with the client. But I try and emphasize, and with my own work and with our staff lawyers, that to be understanding that in addition to mental illness that's presenting, there's often there's a whole context that this person is dealing with. They may have physical or mental disabilities as well. I always try and keep in mind that many of these patients have trauma in their lives, either historical or ongoing. There's victimization quite often, and poverty is a real issue. Housing, just a basic issue. So that's how many patients present with that concurrent problem of housing. There can be lots of hardships. So that's a common theme of what I'm going to talk about is with getting instructions, is trying to be as compassionate and empathetic as possible. The second issue I'm going to discuss is getting instructions. And I know this is a huge issue for all lawyers in all areas of law. It can be a huge issue. I have three important points to make about instructions in this area. First of all, it's a two-way street. I always try and keep in mind both sides of the equation, giving advice and taking instructions. And it's all too easy to maybe put more emphasis on one more than the other, and I think both are very important. It wouldn't be appropriate to just blindly take instructions without giving advice, and it wouldn't be appropriate to force advice on someone without hearing them out and getting their instructions. I'll talk a bit more about that too in the next section. With getting instructions, some clients may temporarily be unable to give instructions to their lawyer. And in fact, it's generally been my experience that it's not a good idea to meet with a patient immediately. Well, I wouldn't do it for sure immediately, but to meet with them too soon upon admission, because, well, I'd want to know the facts of each case, but some people may just take some time to calm down, and there may be a medical issue as well that needs attention, but just to at least a day, I think, generally speaking, or two. Lawyers meet with clients within 7 days, but generally not within the first day. Usually day 2, 3, or 4, they're admitted. It depends on each case. Sometimes it can be sooner, but a lawyer, it wouldn't be wise to just force themselves on a client. I hate saying that out loud, sounds silly, but I always made a point of offering my services to a client if they want it. And some people just don't want a lawyer. They don't want that assistance. So just that ties in with what I'm going to say later about not making assumptions, but just doing no harm and being offering to help and be as open-minded as you can. But with clients that are temporarily unable to give instructions, this can change with treatment. And usually the trajectory is good, that people do respond to treatment and are able to give instructions. And in fact, most people consent to voluntarily staying at the hospital, and most people are discharged much sooner than the 21 days that Mr. Reynolds discussed. But there are some clients who they can have brief bursts of being capable and being able to give instructions, and that can change. It can alternate. In criminal matters, sometimes the label that Dr. Larasby uses is fit but fragile. I guess other people use that label too. And so it can change. But as I said, usually the trajectory is positive. Some clients may not be able to properly instruct counsel because they may be nonverbal or non-communicative, or they may be delusional, psychotic, and so impaired that they just can't give advice, cannot take advice or give instructions. And it can be a real challenge for lawyers. And as I'll say later, being patient and is very important for lawyers in this area. The third issue I'm going to move on to discuss is client capacity. And this was referenced by both my friends in the Act under the definition of mental disorder. And I'm not going to reread that whole section, that definition, but just to give a few highlights that are always emphasized these matters. The disorder must be substantial, so it can't just be trifling or minimal. It's substantial, and the definition is pretty wide open about what fits into a mental disorder. There's thought, mood, perception, memory, orientation. So it's fairly wide, encompasses a lot of different aspects of mental disorder. But the other important point is that whatever that is causing the impairment, it has to be grossly doing so. So grossly impairing judgment. A lot of people in life, a lot of lawyers too, don't have the greatest judgment, and but that's not the test. It's grossly impairs judgment, and also capacity to recognize reality or just be in touch. So there is some subjectivity to it, but that's what we rely on reports from the doctors and a psychiatrist. Patient doesn't always agree with that, as we'll see, but yeah, that's how I tie it in with capacity. Further, mental capacity, I think it's better to conceptualize that as a legal construct in this context, not as a clinical condition. And what I mean by that is, with capacity, I look at it as the ability to understand and appreciate, and the ability to make decisions. So what is mental capacity? It varies across all different areas of law. We have different tests for criminal, family, estates. So there's all sorts of different tests that we use, and a lot of times it's informal when we talk about getting instructions, what that means, and if a client is capable of giving instructions. There are lots of different tests and means of assessing capacity, but the real challenge for lawyers is that we aren't qualified, generally speaking, to do formal tests or assessments. I know there's some exceptions, but I keep in mind, and I remind legal aid lawyers, that by default, it's presumptive that clients are capable and not to make assumptions, as I'll talk about. The fourth topic I'm going to discuss is balancing, particularly balancing the best interests of the client versus client instructions. And there's a lot of tension at times. There can be a lot of tension because what is in your client's best interests from a clinical or medical perspective, that can be totally contrary to what your client's wishes are. And it can be a real struggle balancing that for lawyers. I narrowed this down to 3 important considerations that I think lawyers should focus on when acting for clients who are suffering from the effects of a mental disorder. And I'm not pretending to have easy answers for balancing these things, but I think if these 3 things are kept in mind, it's better. The first is advocacy, and it's a reminder never to confuse your role as the person's lawyer to the point that you forget what client instructed advocacy means. Always remember your duty to the client, and I'll talk about that with the Code of Professional Conduct. Secondly, it's patience. you are often the first person to really sit down and listen to your client and take his or her instructions. Listening is such an important skill for all lawyers in every area of practice and for non-lawyers generally. But I want to highlight it specifically for mental health law, just listening and not just jumping to a conclusion or filling in what you think the person's going to say, but really taking the time to listen. It's something I work at all the time and know I can be better at it. I try all the time to do a better job of listening. I mean, what goes hand in hand with that is time. Like, actually, not all lawyers are kind of geared that way, but to be able to go to the hospital and sit down with someone and spend time with them listening, it's just so important. Not everyone's good at doing that. Third is professionalism. I think lawyers should refrain from passing judgment on your client's choices, however unreasonable you believe those choices might be. You're there to do what your client tells you to do on their behalf within reason, and regardless of your own personal beliefs as to what you think the person can do. Just because a person has a diagnosis of a mental disorder doesn't mean they're stupid. And that's an assumption a lot of people make. And people are entitled to make different lifestyle choices and be respected for those choices. So not making assumptions about the client, that's just so important. And how do you not make assumptions? Well, patience, as I said, taking time, listening, following up. Sometimes an initial meeting is just that, the initial meeting, and there's a follow-up to really make sure you're doing your best to understand what the client really wants and giving them advice to help them determine what they really want. So the fifth topic I'm going to discuss is substitute decision makers in the client's best interests. If a patient is deemed incapable of consenting to treatment, a substitute decision maker may be appointed based on a hierarchy set out in the Care and Consent Act. And just the top of that hierarchy is guardian, advanced directive proxy, spouse, child, parent, etc. And it goes on. And often that's straightforward and makes sense who the substitute decision maker is, and there isn't conflict, but there can be, as I'll touch on. But it's important to note there is a duty on the substitute decision maker to communicate the previously expressed decisions of a patient regarding medication and treatment. And it can be a huge challenge in some cases. There's parallels here with the role of the substitute decision maker and the lawyer in this respect. There's a lot of pressure in some cases on a substitute decision maker to work with the doctors and the hospital and just keep the person there and get them better. But there may be some conflict with staying true to their duty to the patient. So it can be really hard for a substitute decision maker, just like it can be for a lawyer taking instructions versus and balancing that with the best interests of their client. Section 22, sub 6 of the Act sets out determining the best interest of the patient in relation to treatment. And it's another balancing, weighing that has to be considered, looking at, will the mental condition of the patient be improved with or without treatment? Does the anticipated benefit of the treatment outweigh the risk of harm to the patient? And is the treatment the least restrictive and least intrusive? There can be conflict that the lawyer has to address. Sometimes there can be conflict between the substitute decision maker and the client about what is best for them. Sometimes there can be competing substitute decision makers, different family members who have different ideas. It can be a real challenge, but I think if the lawyer just keeps in mind their duty to their client, keeping that first and foremost, that's important. The board can address this conflict by giving direction to a substitute decision maker, or they can appoint a different substitute decision maker or ask that one be chosen. So sometimes that's an issue in these hearings. Okay, finally, the last part of my presentation is about the Code of Professional Conduct. And there are very important principles we could take from the Code of Professional Conduct. I'm not going to read word for word. I'm going to paraphrase some of this in the commentary. but I think it's important, and I'll give some of my own comments. Section 3.2-1, a lawyer has a duty to provide courteous, thorough, and prompt service to clients. Clients should be able to make fully informed decisions and provide instructions. And as I've talked about already, unfortunately, with many of these clients, it can be very hard to get meaningful instructions or to know if the client is truly understanding your advice. And I've already given hints on that, with being patient and taking your time and listening. It can sometimes be hard to figure out what instructions are and how to give the right advice to fit with each client. But there isn't one size fits all for helping all these clients. Every situation is a little different. Section 3.4-1, acting for a client. The lawyer-client relationship is based on trust, and it's a fiduciary relationship, and as such, the lawyer has a duty of loyalty to the client. And I think one thing to keep in mind is mental health clients are vulnerable, as I've mentioned. The lawyer is often, that's it, the only person that's there representing their side, and to take that duty very seriously. 3.2-2, when advising a client, a lawyer must be honest and candid and must inform the client of all information known to the lawyer that may affect the interests of the client in the matter. And the commentary, I think, was quite applicable to mental health clients and lawyers. In communicating with the client, the lawyer may disagree with the client's perspective or may have concerns about the client's position on a matter and may give advice that will not please the client. This may legitimately require firm and animated discussion. And that's particularly relevant. What comes to my mind is clients who have tried or have threatened to seriously hurt themselves. And that usually people aren't hurting other people in mental health. That does happen, but I'm thinking of this, a common case where someone is either hurt themselves or is threatening to hurt themselves badly, suicide or something else. And it can be so hard to tell someone, that like they want out, they want to get out and have their liberty. But I emphasize with those clients, people care about you and really want to see you get better and get okay. But I mean, as the code of conduct says, you have to fully inform the client and give them all that context, but you also have to be professional and give them proper advice, realistic advice. At the same time, a lawyer, another thing to keep in mind is, I think about this with criminal law too, but a lawyer has a lot of power over a client. A lawyer can steer a client into a lot of things, including waiving the right to a hearing or consenting. It's so important to resist that. There's so much pressure from everyone to just push this person into going along with things. And lawyers need to be really careful not to do that. Same with guilty pleas, criminal clients. They're very vulnerable and facing a lot of challenges, and it's all too easy. There is a lot of trust usually with these clients and lawyers, and they will nod and agree with what the lawyer's advice is usually. So giving options as clearly as possible and emphasizing the rights of the client, that it is their right to a hearing, and they aren't in trouble, and no one has the right to pressure them or be mad at them just because they want out. That's the default. People should have liberty and freedom. Lastly, 5.1 sub 1 or dash 1, when acting as an advocate, a lawyer must represent the client resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect. And the commentary, the lawyer should never waive or abandon the client's legal rights without the client's informed consent. And I've touched on this a little bit, but I will also add that the client's liberty is at stake. The state's detaining them against their will and treating them sometimes against their will. Sometimes they want to transfer them to a facility down south, psychiatric medical facility. It can be terrifying. It can be really scary for the client. And I always emphasize with the client how I would feel in their shoes, being taken away from my family and friends and not be able to go to work. It would be terrifying for any of us, albeit the context is people want them to get better and help them. Just being really careful, and as a lawyer, resisting all the pressure to just go along with things. I'll say that again, because it's hard for me too. It's these things take a lot of time and a lot of work, and it would be easy to lose sight of the client's rights, and or to minimize them in any way. And I just think it's so important to keep in mind your duty to your client. So that's all for my part of the presentation. And I see there's some chat showing up. Oh, Q&A. If we were live, I would say, just ask if there are any questions. It'd be easier. I see already there's a couple questions in already. Someone typed, I can't find the usual mute and video buttons. I hope we were seen and heard, and that's not too late. I just saw that now. So I see there's still 55 attendees, which is amazing. I'm shocked that many lawyers signed up for this. We'll take questions. I see the first one here is regarding substitute decision makers. And Jim, I don't know if you want to look at this too. Mike, I don't want this to just be all on me. Are you still considered to be involuntarily committed under the Mental Health Act if the substitute decision maker has consented to my care while I'm incapable?
Yes. Yes, you are. The substitute decision maker, it has a role in consenting to the care that is provided to the patient, but involuntary admission is a separate process under the Mental Health Act, which basically means that the patient is not able to leave hospital for the 21-day period while they're involuntarily admitted. But while that is going on, substitute decision maker is still, I get to sit, is still involved, still consulted and notified with respect to treatment, and consent is sought. It's required under the Mental Health Act. So
I wonder if there's any.
I hope that answers the question. We have wheels, so I'm going to roll off the side.
Oh, there's 6 now Q&A. Okay. Oh, now they're all coming. What are the causes attributable to the year-by-year increase in cases under the Act? I think each of us can have a comment on that, but Jim, you really looked at this specifically.
Well, it's interesting actually, because it's very difficult to say whether we have more mental illness in our community, whether it's more prevalent or whether we're identifying it and treating it more. We had a situation where we had one local psychiatrist for years, and now we have 4, I believe, local psychiatrists. Also, I think that the community is tuning in more to the issue of mental health and is becoming more aware of mental illness and mental disorder, and so it's being perceived and treated more. I can tell you that there are seasonal variations, which I can attest to, where, for example, we get spikes in the number of people coming in under the Mental Health Act around Christmas time and around June with the equinox. You can attribute that in the winter to darkness, to SADS, but also to Christmas. A lot of people find that to be a depressing factor, believe it or not. In the summertime, the converse is true. The incessant daylight and the impacts on people's sleep, which can cause a spike. And right now, I can tell you that we are getting more matters being dealt with under the Mental Health Act than ever before right now. And I think that's because of the overlay of the pandemic, of course, which is creating an overall environment of fear and isolation. And it's just very difficult it's difficult to measure or attribute, a degree of responsibility to any one particular thing, but certainly the pandemic's a big one.
I think too, related to that is there's more, we have dedicated psychiatrists, plural, involved in this, and a secure medical facility that for the first 10 or so years I was in this area of practice, there wasn't. So there's more resources and more knowledge, and I think the RCMP is doing a better job too at being sensitive to mental illness, and we're making referrals, commencing these applications. So it's obviously tied with housing, I think, too, and poverty as well. There's correlation there. Oh, sorry, Mike.
Yeah, and I also, if I could just sneak in, or I also think society has evolved a little bit where now we're prepared to recognize mental health and we're perhaps on the lookout for it. Whereas before it used to be, used to be probably kept a bit of a secret, a lot of stigma attached to it. I think that's, possibly a contributing factor at least. The other season that seems to really fill up the secure medical unit at the hospital is spring. Spring seems to be a very stressful time for people as well, but particularly with mental health. I would think it'd be a time of hope, but not for everyone.
Maybe with daylight savings being removed, we won't, I don't know. Okay, there's some, I hope we get to all of them now. There's a lot of questions. Does the category of peace officer include officials other than the RCMP?
Well, I just checked the Mental Health Act. There is no definition of peace officer under it. We all know the criminal code definition is more expansive than RCMP. What I can say is that we have never, best of my recollection, never seen anyone other than the RCMP apprehend someone under the Mental Health Act. But that's probably because when problems occur, there's no one other than the RCMP that's regularly responding to those problems. People don't call bylaw when when they see someone running naked down the street. They call the RCMP.
The next question, what would you do if a mental health professional tells you something and says, don't tell the client because it could harm them? That actually comes up in other areas of law too. And I try my best to say, well, don't tell me anything I can't tell my client. But in the therapeutic context, I would never hide anything from my client, but I might handle it delicately and carefully. I wouldn't want to harm my client either, but that can be tough. But I think the duty to the client overrides everything. It's the primary duty. How often do you end up dealing with individuals with dementia? And are the issues that arise with them that don't arise with people with mental health problems? I think in my experience, it's been there, but definitely not the majority. It's a small portion of the clients. And over the years, I keep thinking with the aging population, that's going to increase, but I haven't necessarily seen an increase. I don't know if you guys have.
I haven't seen an increase, but I believe that most people with dementia are probably in the care of family or most people are being offered direct assistance before it becomes a problem that would hit the Mental Health Act sort of threshold.
Yeah, I was trying to read the question. Sorry, you're now in my my
Sorry,
bubble.
we're in a bubble here.
Yeah, with respect to dementia, I think if there is an act that those individuals are dealt with, it's often the Care and Consent Act, and we do occasionally see admissions from some of the long-term treatment facilities at the hospital under the Mental Health Act, but that's usually a very we'll call it sort of an acute situation, perhaps some violence or things that facility isn't necessarily able to take care of. Maybe some medication needs to be sorted out, but those are generally short stays, but they do occur, and it is usually something very much out of the ordinary happening at the facility with the patient.
I think the thing to remember is that it's with dementia, there are two aspects to the test. First, there has to be a mental disorder, and then there has to be a risk or danger presenting itself. And it does happen that people with dementia find that either risk or danger being presented to themselves or to someone else, but it's not often the case.
Oh, wow, there's lots. There's some under chat and some under Q&A. I'll try to get to each of them in turn. This question is about stats. You've touched on this, Jim, but why there's been a steep and steady increase in the number of processes initiated every year. Do you have anything more to add?
I think over the last 2 years, I can comment. It's been a steady increase for sure. I think it started with a societal sensitization to mental health and mental illness. So people were becoming more aware of it. But over the last couple of years, particularly, we've seen the change where we went from 1 to 4 local psychiatrists. So we're seeing a lot more people being diagnosed and treated. And then, of course, this year we have the pandemic. And I can say right now, I'm not talking about hearings because most matters don't go to hearing. But for example, if I recall correctly, in the first 7 days of August, we had 8 matters come in under the Mental Health Act, if I recall correctly.
Just a random question, Jim. How long have you been chair?
I forget.
I think it might be 2 or 3 years.
It's been 2 or 3 years, yes. But I was involved prior to that for
Alternate chair, right?
yes,
Yeah.
for several years.
Yeah, I'm not suggesting you're a cause at all, sir.
Oh, I didn't get what you were saying.
Now it's funny. The other issue that I think we need to recognize too is the community resources for mental health probably have increased over the last several years. I know the advent of mental wellness, substance use services. We do now have more psychiatrists than we ever used to. I guess the point is perhaps that there are more people involved officially in what we would term the mental health system than ever before. And when those individuals show up at the hospital, perhaps it's they're being recognized, or their issues are a little more obvious or more well documented. I don't think we've really suffered or seen a population increase or anything like that, but I think the resources to identify and treat mental health in the community have increased. Maybe that's part of the issue.
Yes, will the recording and flow chart be available for review? Yes, that is available on request, the documents from the Law Society, but also the actual presentation, I believe, will be archived and available at some point on the Law Society. As the CPD committee, we've talked about this, about making, as much as possible, making these courses available, archived and available afterwards. Do patients have a right to a second medical opinion? Well, I think that's the process itself. It's 2 doctors and a psychiatrist, and if the patient doesn't agree, they do have the right to consult with their own expert, but those are far and few between. But also, the board can also address that issue as well.
I think that the process happens so fast because basically the initial referral for examination triggers a 24-hour period within which they have to be, if it goes forward, they have to be examined by 2 doctors, one of whom is likely a psychiatrist, and they both have to approve the involuntary admission by their certificates within that 24-hour period. And if they don't, then the person is not involuntarily admitted, they're let go. And then we have to review it within 7 days. So the patient is able to bring whatever evidence the patient has, and that if they can and want to get another medical opinion to counter that which the doctors will be bringing, they can. I can say, practically speaking, I don't think it ever happens, just because it's so quick and once we review, and we have to do the review within 7 days. Once we review it and then we either we uphold it or we don't. And if we do uphold it, then that person is involuntarily admitted. I guess they could apply for a further review after that if they do get a second, if they go and get a medical opinion. But most people involved in this process are not in a position to, practically speaking, obtain another medical opinion.
Well, and just logistically, I'm not sure where that second medical opinion would come from, because if we're dealing with a limited number of resources to provide a medical opinion to begin with, and I take the point of the question, but logistically, I'm just not sure how that would be facilitated.
the board hears other people's opinions, not necessarily medical doctors, but sometimes support people come in and give their opinion. And the board will hear anything from family, from support people. Sometimes nonprofit agencies have sent support people or First Nations. And if anyone wants to help, I welcome that, as long as the client's okay with it. I think there should be more support, so it isn't just that poor lawyer alone with the client, but that there's support people helping them to convey the person's best interests. Transfers, that's a huge issue. How many patients get transferred? That was on your stats sheet. The
I'm
summary.
sure was the answer to the question, do many patients get
Oh, it's been
transferred?
answered, I see here.
Is yes.
Yeah. How many cases, okay, that's answered in stats. How much interplay is there between the MHA process and referrals to the review board? Are fitness assessments ever done while patients are admitted under the Mental Health Act? There is overlap. Just I know from my own clients, some have been in both processes, but I don't know what the stats, if they're measured at all.
I think there may be overlap in that the same people may get involved in both processes, but the MHA is dealing with treatment. The review board is dealing with a different subject matter. So while it may be dealing with the same people, I think practically we never speak to each other.
If the patient's lawyer cannot get instructions from a patient, does the board conduct a hearing for involuntary admission, or is there a paper review? If so, why?
Yes, what we need is a waiver. So there will be a hearing in the matter of an involuntary admission or a transfer. There will be a hearing. We're mandated to conduct a hearing unless the patient waives it. They have to be able to waive it, and they have to actually waive it. We have a form. And if we don't get that form, we can receive it. I think if they have counsel, their counsel can send us correspondence indicating that they're waiving the hearing, and we'll accept that.
In my experience, the document itself is intimidating for some clients, making them sign something when they're committed. So if some clients are willing to sign the form, and that's the safer approach, clarifying that they understand their legal rights and they're waiving their right to a hearing, but I can convey that information. The lawyer can convey that information to the board in writing. And I always make sure I explain the act and their rights and confirm my instructions that they're waiving the right to a hearing. But if they haven't explicitly waived their right, either by signing or verbally, then it has to be a hearing. And that's, you saw the stats, there could be quite a few hearings at times. Are there more Indigenous cases or youth? I don't know if we track, those things aren't specifically tracked.
We haven't been tracking them, but there are a lot of Indigenous cases. We have a large Indigenous community, and a large portion of that community is vulnerable. But we also have a lot of youth cases, and we've dealt with some very tragic circumstances with patients who were as young as 13 years old.
And sometimes that can be hard, I know from experience with similar to representing youth criminal justice clients, where the parent's trying to give you instructions that are contrary to the client's instructions, and the duty is to the client, to the youth, not to the parent. What judicial review process is there, if any, if the patient wishes to challenge the board decision? Is there a private clause ousting the court power review?
I think they have I think they can appeal it.
It's Supreme
It's in the
Court.
Supreme Court.
It's not it's actually an appeal, right of appeal to Supreme
There
Court.
haven't been many over the years. I think there's one reported, or maybe two.
Yeah, within 30 days of the order being made, you can appeal to the Supreme Court.
Is the test for mental disorder under the Mental Health Act different from the medical test for mental disorder?
We don't know what the medical test is for mental disorder, but mental disorder is a defined term under the Mental Health Act. Once the doctors get involved and they diagnose specific conditions, and I can say from conducting hearings that when we do our review, like like I said, the definition of mental disorder is not a medical definition. It's a practical definition. Because frankly, when we have a situation with a person who's suffering from a mental disorder as we've defined it, and they're a danger to themselves or to someone else, there's no time to sit around waiting for a diagnosis to occur. And sometimes a diagnosis takes a long time to do, an actual medical diagnosis. So the doctors have different tests to employ for different different conditions of mental illness. And if they give us that, great, we can tick that box. If they don't, then we go through the test of what is a mental disorder, whether there's a significant, a substantial disorder of thought, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize, etc. So we go to the practical. If we can't get the specific medical diagnosis, we go to the practical, because that's all we need to get in under the Act.
Good. Security arrangements for potentially violent persons. As I said in my presentation, thankfully, most people admitted that aren't a risk of harm to others. That does happen at times. Most people are more risk of harm to themselves, or their mental health is deteriorating so significantly. That's another part of the test. But I can count on, I think, just one hand the number of times that we've had to involve the RCMP or security. Sometimes the hospital security has escorted a patient, but I think more in those cases, there's a concern the person's going to run and take off, and they have to be supervised. But there have been the odd violent case. I mean, it's like at legal aid, or we haven't had, thankfully, we've only had a few incidences of violence like that. Thankfully, it's quite rare and exceptional, but
It does happen. If the person is incarcerated at the WCC, the Correction Center, then they need to come down for an assessment. They come down, I think, under the authority of the superintendent, and they remain in the custody of the WCC, is sort of my understanding of it. I can say that under the Mental Health Act, which is more our department, there are powers available to the doctors to restrain, either physically or chemically, but only in extreme circumstances, only when it's absolutely necessary.
And it can be quite problematic to deal with individuals exhibiting extreme violence, because what we have to remember is the secure medical unit is essentially a wing of the hospital with a locked door and some very good and talented and caring people working in there. But it's not a forensic institution. It's not a jail. And when someone needs to be restrained, we're dealing with a bunch of nurses and doctors, not corrections officers and RCMP members. And a lot of times the calls do go out to the RCMP for assistance, but we all know how busy the RCMP are. So it can create a lot of difficulties, both for the patients, but also for the people that are caring for them at the hospital.
okay. Let's see. How often does the board overrule a physician's determination about capacity? I thought at first the question was going to be, how many times do lawyers win these hearings, which I'd say almost never. But this specific question.
The doctors don't typically make, the question is incorrect. I think it is rude a little bit. The physicians don't typically make determinations about capacity.
That's right.
It's, they make a determination about whether the person has a mental disorder. And we look at the evidence in total context, including, so the test, going back to the test, is not whether they have capacity. It's whether they have a mental disorder and whether they present a risk to themselves or to someone else if they aren't involuntarily admitted. It's not about capacity.
So that's in this this chain question answer, it's everything. But now I see there's others maybe here, Zoom webinar chat. Let's see.
Can we turn that off?
No, they're positive comments. Everything. I don't know. I don't see any other questions in either part. We're at 20 after. That's. I'm glad we got to this point. 20 after 1. I was worried there wouldn't be any questions at all, and there were quite a few good ones. I'm not seeing any other pop up. So going once, twice, 3 times. Okay, I think we'll end the CLE then, if that's okay.
Thank you very much.
Yeah,
Yeah.
thanks for attending, everyone.
Yeah, thanks. Have a good rest of your day.